remind us, it's been day 2 that we've been hearing questions around really Section 230, the protection it gives technology companies, and in many ways against anti-terrorism laws in particular. The argument today was what? That Twitter should have been taking down certain content to prevent what happened in Istanbul.
That's correct. The argument in the court today was that Twitter was not vigorous enough in taking down content. And I kind of find that somewhat amusing because a lot of the criticism of Twitter and the other social media companies over the past year or so has been that they censor content that is available on those media platforms. So the fact that they are now being criticized for not being vigorous enough, to me, really points out how difficult this whole area of content moderation is on social media.
And to that end, it's become politicized. On to broad brushstrokes here. On the right, on the Republican side, there's an argument that they don't want conservative viewpoints taken down. On the Democrat side, it's more about that they shouldn't be leaving certain content up and should be putting it down quickly, harassment, hate speech and the like. How much has the Supreme Court been weighing in, and should they be?
They've been asking pretty good questions, and I would say if you had to read tea leaves right now, I think the court as a whole is skeptical that you can just rip out this layer of internet recommendations and the world would function normally. When you think about it, if you took out the recommendations that are really based on the user's own preferences and the user's own viewing habits, then what would we be left with? Just every time a user comes to a page, they have to do a new search and they don't know what kind of content will come up.
Talk to us about Silicon Valley or social media companies writ large's response to this. Many have argued, look, we need this protection, obviously, because there'd be a flood of legal issues that they'd face, but not just big companies, small ones too.
You know, Section 230 came about in 1995, 96, and it was in response to a case where Prodigy, if you remember that far back, was an online network, and they were held liable for a defamatory post that was made on the Prodigy service. And it occurred to Congress at the time, and I think this was a correct decision, that an internet ISP or a big web platform is really more like a newsstand or a bookstore. They're not publishing the content, they are making it available. Now, the really interesting aspect of this case is that YouTube has a recommendation algorithm, as many other services do. And so when you search for something, it's going to recommend several videos and a string of videos. But those recommendations are not actually technically made by an editor at YouTube. They are based on what the user has looked at before. And then they're based on what the most popular videos have been on that subject. So I think it's really not an editorial function per se.
But can anything be done? We look to Europe, we see some of the rules that are going to come into place in 2024. Ultimately, is there something that the Supreme Court or indeed Congress could do to make the searching less involved in hate speech?
What I think we could do is have more transparency as to how the algorithm actually works. That would be good. And then we could actually give users more control. Let's say you could have settings that said, I want to hear more of the things that I like, or I want to hear more of the things that I don't like, or just give me a random news feed. Facebook actually does a version of this in the news feed where you can highlight certain friends and de-emphasize other friends. And I think that giving users control over the content that's recommended is the way to go.